front of the judge and say, Your Honor, what he is saying may be true, but there are other reasons. There's another explanation as to why I did what I did. So, quick hypothetical. Let's say we are representing a real estate developer again. And let's say that this developer owns all kinds of assets. He is very wealthy. And let's say that one of the assets that he owns is a large apartment building. And one day, mold is discovered in this large apartment building. And the next day, this apartment building is discovered by some enterprising plaintiff's attorney. And the plaintiff's attorney files a class action lawsuit on behalf of all of the tenants against the developer. The developer goes to his defense attorney, how good is their case against me? And the defense attorney says, you should be worried. I think they will get a large judgment against you. So what does the real estate developer do? The real estate developer takes all of the assets that he owns and he transfers all of his assets to a limited liability company. He owns this LLC, he just set it up, takes all of his assets, transfers them to the LLC. Let's say that the lawsuit is concluded, there is a large judgment for the plaintiff. The plaintiff starts looking for the assets that this real estate developer owns, that they can satisfy the judgment with. And they find out that the only asset that this developer owns is an interest in a limited liability company. And as you'll find out in a little bit, it is not a very attractive asset to pursue for a creditor. So what does the plaintiff do? The plaintiff goes back to the judge and says, Your Honor, this guy, he transferred all of his assets to a limited liability company. It makes it more difficult for us to collect. He transferred his assets to the LLC after we filed the lawsuit. He controls this LLC. We think he was insolvent at the time and so on and so forth, trying to establish as many badges of fraud as they can. What is the real estate developer going to do? The real estate developer is going to go to the judge and he's going to say, Your Honor, you're not going to believe this. Although probably not the best opening line for the judge, right? He's going to say, Your Honor, just after this lawsuit was filed against me, I came across the most amazing business opportunity. I was going to make so much money of this business opportunity, I could have easily paid off this judgment. So what did I do to pursue this business opportunity? I formed a joint venture vehicle, this limited liability company. And I transferred all of my assets to this LLC because I was going to sell them and convert them into seed money. And here's a list of all of the investors that I talked to for this new project. Here's a list of all the banks that I solicited for loans. Here's the marketing plan that I wrote up. Here's my business plan, and so on and so forth. I did all of this for a legitimate, actual specific business purpose, not because I was trying to defraud this creditor. What does the judge do? For the judge, it's a very subjective analysis. Who is more believable? The plaintiff establishes some badges of fraud. The debtor comes in and says, well, there's different explanations to why I engaged in all of these transfers and these structures. Who does the judge believe more? Okay? At the end of the day, being able to establish this actual intent to hinder, delay, or defraud a creditor is really all about likability to an extent. It's all about our client's ability to pass the so-called FACE test. Those of you who are not familiar with FACE test, well, the lawyers should be. You probably covered it in law school, but those of you who are not lawyers, the FACE test is your ability to go in front of the judge and explain what you did and why you did it without your face turning red. Okay, that's the FACE test. Or, in other words, a smell test. We have to create a believable explanation as to why our client engaged in this type of planning. Maybe the client was simply doing estate planning, and he transferred some assets to a living trust, he drafted some wills and healthcare directives, and maybe some assets went into an irrevocable trust. Yeah, it's true the irrevocable trust gives him some asset protection, but maybe that was not the primary reason for setting it up. Maybe it was just kind of a nice fringe benefit. And with the fraudulent transfers, the creditor has to establish not only that the client intended to protect his assets, the creditor has to establish that it was the client's primary intent in engaging in these transfers. Not an easy thing to do. you will find that in practice, proving a fraudulent transfer by showing the debtor's intent, by showing these badges of fraud, is a very difficult thing to do. Okay? Not impossible, but very difficult. And you will find that in practice, most creditors focus on the same test, the so-called constructive fraud test that's at the bottom of your slide. And under the constructive fraud test, there is simply no subjective analysis. We look only at numbers. You will have a transfer that is constructively fraudulent, and therefore a fraudulent transfer, if the debtor transfers assets for less than fair market value, meaning it's some sort of a gift transfer, wholly a gift transfer, maybe partially a gift transfer, and at the time of the transfer or as a result of the transfer, the debtor is insolvent. Okay? Only looking at numbers, nothing else. Why did he do this? We don't know, and we don't care. We're simply looking at the numbers. So transfer for fair market value, very simple, very straightforward. We know the value of the assets that the debtor owns. He transferred them away. What did he get back? What is the value of whatever it is that he got back? So if we are worried about a creditor bringing a fraudulent transfer challenge, we need to be aware of the fact that the creditor will want to establish that our client transferred assets for less than fair market value. It's a necessary element for the constructive fraud test, and it's also one of the most important badges of fraud, which means that maybe we do not then want to engage in some sort of a gift transfer when we are setting up our asset protection plan. For example, maybe instead of transferring assets to an irrevocable trust, and we'll discuss those in more detail later on, we will transfer assets to, let's say, a limited liability company or a limited partnership. Why is an LLC better than an irrevocable trust? Well, it's not necessarily better, but from a fraudulent transfer standpoint, if you transfer assets to a trust, what type of a transfer is it usually? Well, it's usually a gift transfer. You just gift the assets to the trust. If you transfer assets to a limited liability company, is that a gift? No, because you get something back from the limited liability company. What do you get back? You get back an interest in this LLC. So it's a transfer for fair market value, which knocks out the constructive fraud argument right off the bat. Okay? Because if it's a transfer for fair market value, we never even get to the insolvency part. So again, if we are planning at the time when we think the plaintiff, the creditor, will argue that this was a fraudulent transfer, we want to make sure that the transfer is for fair market value. That will make their job a lot more difficult. Insolvency, which is the second factor of the constructive fraud test, refers to the client's balance sheet. We look at the fair market value of the client's assets. We look at the fair market value of the client's liabilities. If assets exceed liabilities, or if they're equal, the client is solvent. If liabilities exceed assets, the client is insolvent. And we look at both assets and liabilities from a fair market value standpoint, meaning what is the fair market value of the lawsuit that was just filed against our client? Well, how much money are they asking for, and how much money are they likely to get? What are the odds that the plaintiff will prevail? We can calculate what is the fair market value of this lawsuit. There's a contingent liability our client is subject to. We want to discount that contingent liability. Our goal in representing debtors is to make sure that they have a balance sheet that has assets in excess of liabilities, so that our client is solvent. Because if the client is solvent, constructive fraud does not apply, and again, it knocks out the most important badge of fraud. So we want, and we do this with every single new client that comes to this office, we will ask them for a balance sheet. What is the fair market value of your assets? What sort of liabilities are these assets encumbered to? What other liabilities do you have outstanding in general? We will talk about to the defense attorney about the value of this lawsuit that was filed against our client or is likely to soon be filed against our client. And we want to wind up in a position where the client is solvent. You often hear attorneys scare their clients with this idea of a fraudulent transfer. You know, oh, you